Good afternoon, everybody. A very warm welcome to those who are joining us here in glorious sunshine in Northcote, Georgia Street, and hello to those who are joining us online. My name is Maria Kotsoni, and I'm the Director of Research here. I'm really pleased to welcome Dr. Maria Kotsoni to the Institute in person in full Technicolor. A very warm welcome to Dublin. And the topic of the discussion today will be constitutional change and the rise of fiscal discipline in Europe, ripple effect on fundamental social rights. A more important or consequential topic I can hardly imagine. The normal caveats apply. So this event is on the record. Maria, you're going to speak to us for about 20 minutes in a little while. I'll have the pleasure of introducing you formally just before that. Those of you who are here or those of you who are online, you're very welcome and indeed strongly encouraged to participate in the discussion by using either your hands if you're here or using the chat function on Zoom. Is that all the essential housekeeping? We can probably get down to business then. I just want to acknowledge as well, there's a couple of friends in the room, but Professor Roland Earn, who's an old teacher of mine back from UCD days. It's great to have you here, Roland. Some of the classes I took with Roland determined what I've done for the subsequent 20 years. So it's great to have you in. And indeed, Roland is one of the real global experts on the topic that we're discussing here. So just to give the proper introduction now, Maria. So Dr. Maria Kotsoni is a postdoctoral research fellow at Princeton University. Maria's research focuses on the protection of social rights at constitutional, European and international levels. Maria obtained her PhD from the European University Institute in Florence. Indeed, we established recently, we briefly crossed over there, I think. So it's great to have a fellow alum. And Maria is a consultant to the Council of Europe's Department of Social Rights. So Maria, if you're happy, if you can take to the podium, and we have about 20 minutes. And if you can just welcome Maria in the conventional way.
Thank you, everyone, and Barry and Dylan for hosting me. Just to recall the title, Constitutional Change and the Rise of Fiscal Discipline in Europe, Ripple Effects on Fundamental Social Rights. And I'm going to start unpacking what this means, actually. So, following the economic crisis of the late 2000s, European constitutional orders were faced with the question of whether they should incorporate balanced budget rules and other fiscal constraints into their national constitutions. And by fiscal constraints, I broadly mean rules prescribing a balance between revenue and public spending and rules containing public debt. And this issue came up from eurozone legal responses to the euro crisis that aimed at increasing oversight over national economic and budgetary policies. And as a result of euro crisis legal instruments, several EU member states have adopted balanced budget constitutional amendments. These constitutional amendments, by which I mean changes to the formal text of the Constitution, aimed at making or enhancing constitutional fiscal discipline in Europe, in EU constitutional orders. And what I claim is that these changes might be a product of the euro crisis, but the relevance and outcomes have far exceeded the euro crisis origins. And we can think, for example, of the impact of these rules in important fields of state action. And some of you might be familiar with a case in 2023 where the Federal German Constitutional Court restrained budget transfers to a climate fund dedicated to addressing climate change, recalling this exact constitutional rule of fiscal discipline and debt break. Now, in my presentation today and the article on which this presentation builds, I make three different but related and overlapping points. So the first one is that the constitutionalization of fiscal discipline has had an impact beyond the euro crisis, that informal constitutional change is useful in understanding how EU fiscal rules interacted with national constitution and the impact of these rules. And third, and most importantly, that constitutional rules of fiscal discipline, no matter how they're constitutionalized, they have an enduring impact on fundamental social rights, and they have reshaped fundamental social and labor rights in EU member states. So, part one, the rise of constitutional rules of fiscal discipline in Europe. Now, the idea of having a rule in a constitution or constitutional provision that prescribes some form of fiscal constraints is not new. Several jurisdictions in the world have adopted relevant constitutional provisions that can take various forms. For example, again, balanced budget rules, debt breaks, limits on public spending, or a combination of the above. And in other places, we see long-standing debates on whether a polity should move towards this direction. And we can think balanced budget rules in South American and South African constitutions, for example, in post-colonial constitutions in general, and a long-standing debate on a federal balanced budget rule in the United States, where currently relevant rules are constitutionalized at state level. So these developments have preceded the recent European dilemma. Now, in Europe, while fiscal rules have existed on a sub-constitutional level for a long time, and occasionally they appeared in constitutions like the Salazar Constitution, the fascist constitution of Salazar in Portugal, fiscal discipline was definitely not a mainstream feature of European constitutionalism, by which I mean the post-war constitutions, post-war, post-Soviet, and post-fascist constitutions of Europe. And the Euro crisis was a critical juncture in this regard, in mainstreaming this idea and posing this question of incorporating this type of fiscal discipline rules in constitutions. And the reason why is that aside from financial assistance conditionality prescribed in Memorandum of Understanding and austerity programs, EU legal response to the Euro crisis also included legal sources aimed at increasing oversight over national economy and budgetary policies. And an example is the Euro Plus Pact in 2011 that introduced this idea of giving constitutional expression to rules of budgetary stability. And other legal sources follow directives, the two-pack, which is a framework that, however, has undergone recent reform. But from a constitutional perspective, which is what I'm looking at, the most significant measure was the Treaty on Stability, Coordination and Governance in the Economic and Monetary Union, known to most of you as the European Fiscal Compact. So this treaty was an international treaty signed in 2012 by EU member states, excluding the UK and the Czech Republic. And Article 3 of the treaty, which is what the European Fiscal Compact actually refers to, provides that the budgetary position of governments shall be balanced or in surplus, and that this obligation should be internalized in EU member states through provisions of binding force and permanent character, preferably constitutional. And with this preferably constitutional, with this term, the Fiscal Compact openly attempted to constitutionalize fiscal constraints at an EU member state level. And Germany was the first EU member state to amend its basic law to enhance pre-existing constitutional commitments to budgetary stability in 2009, which is prior to these European legal instruments. But following the Euro Plus Pact and the Fiscal Compact, other EU member states like Spain, Italy, Slovenia, Hungary have adopted relevant constitutional amendments, while you probably know and voted in that referendum, Ireland also amended its constitution to authorize the ratification of the treaty, while not prescribing directly a balanced budget rule in the Irish constitution. Now, here we see different ways of internalizing these rules, and some countries went, this is of course part of EU member states, but some countries went with ordinary laws, others with constitutional laws or constitutional amendments. Now, this trend of entrenching balanced budget rule in European constitutions has been to some extent theorized, especially in the immediate aftermath of the adoption of the Fiscal Compact. And I'm talking here about a legal analysis and constitutional law and European law accounts. But these accounts first focused on the Euro crisis period, but most importantly adopt what I claim is a narrow understanding of constitutionalization and what it means to constitutionalize balanced budget rules. So my argument is that we can see that in certain cases that rules of fiscal disciplines have entered the constitutional sphere of EU member states without changing formally the constitution. And to show that, I used the case study of Greece, my home jurisdiction. And as some of you might know, Greece was the first eurozone country to enter a bailout agreement in 2010. It signed 3 bailout agreements, active for an overall period of 8 years. And while Greece did not adopt a constitutional balanced budget rule, I claim that it has constitutionalized similar obligations. Now, it is surprising, perhaps to some, that Greece did not change its constitution, but this is explained by a combination of constitutional design and political disagreement on the matter. So, the Fiscal Compact gave a specific time frame for adopting 2 member states to adopt legal instruments to internalize the obligations. And because of Greece's constitutional amendment rules that are prescribed in the Constitution that dictate a 5-year wait between constitutional amendments, a balanced budget rule could not be adopted in the immediate aftermath of the beginning of the euro crisis and the adoption of the Fiscal Compact. However, the matter was brought up again in the constitutional debate in the context of the most recent constitutional reform in 2018 and 2019, where the right-wing New Democracy party that was the main opposition at the time and now in office proposed the introduction of a balanced budget rule in the Greek constitution. And at the time, Syriza, that was then in government, was opposed to such a reform, and this is why this amendment project, this constitutional revision project, did not pass the supermajority test required to become a definitive constitutional amendment. However, it has been brought up by members of the current government that they will try again to amend the constitution to prescribe a balanced budget rule in the Greek constitution. So again, my claim is that this lack of formal constitutional change on the matter does not mean that Greece has not constitutionalized fiscal discipline rules either, by other means. So in my work, I argue that the Greek constitutional order has bended to the needs of norms of fiscal discipline. And to explain what I mean by that, I think it's important to recall the place of international law within the Greek legal system. So, again, the Fiscal Compact was an international treaty, and Greek constitutional law prescribes that international agreements that are ratified have a status that lies between the Constitution and ordinary laws, and as a result, no ordinary law might override international treaties, like the Fiscal Compact in our case. And at the same time, Greece has transposed all directives that are relevant for EMU fiscal governance, but also ideas on fiscal stability and prudence have underpinned lawmaking, and especially the laws on budget and the medium-term fiscal frameworks that I found that adopt the language of fiscal discipline and the language of fiscal prudence. But what interested me the most, being a constitutional lawyer, was to see how fiscal discipline was perceived in courts, right? And the way courts dealt with these new rules and these new ideas for Greek constitutionalism. And I looked at how they dealt with the austerity litigation. So, unlike Ireland, Greece, the Greek austerity program led to lots of challenging of measures in courts, in Supreme Courts, on the basis of social rights, labor rights, but also principles, constitutional principles of equality or the welfare state, for example. And I'm talking here about more than 100 cases, right, that reached Greece's apex courts, and then constitutional adjudicators had to interpret and decide on the constitutionality of measures. So I did that, and I looked at how Greek apex courts judges dealt with fiscal discipline and social rights, and I then moved on and compared the trends that I saw in Greek adjudication with a jurisdiction that has a balanced budget rule amendment in the constitution. And this is Italy, that changed its constitution in 2012 to incorporate the golden rule as prescribed by the Fiscal Compact. So what I found was that the 2 case studies, Italy and Greece, while having had different experiences as to how they internalized and they constitutionalized European fiscal constraints, they indicate similar outcomes for the treatment of fundamental labor and social rights. So the first comparative point is that both Greek apex courts and the Italian Constitutional Court balance social rights against fiscal discipline. This means that social rights that were entrenched in these two constitutions since their making in the post-fascist era now had a competition. In Greece, the tension came about by a new content that was attached to the idea of, to the concept of public interest. So public interest in the social rights litigation, but more broadly, was conflated with the fiscal interest of the state by reference to different versions of fiscal prudence and fiscal stability. This meant that social rights had to be balanced against this idea of the public interest, which was a novel content for this constitutional concept. So the first ripple effect is the tension between two different parts of the constitutions that clash, by which I mean the fiscal constitution that has been advanced in the post-crisis era and the social constitution that formed part of this post-war promise for a welfare state and for social citizenship along democracy and rule of law. And social rights sometimes might win this test, they sometimes might lose, but my point is that they have to pass the test in any case. And actually, in most cases, social rights did lose, and fiscal rules ended up having a limiting effect on them. And I'm talking here about a big span of rights, like collective labor rights, employment conditions of civil servants, pension rights, and healthcare rights. And there are some notable exceptions to this rule, and I'm going to show you that quote. So this is a 2016 decision concerning funding for education of students with disabilities, where the Italian Constitutional Court stated that it is a guarantee of inviolable rights that must condition the budget and not the opposite. But again, this is an exception to the rule. In both case studies, I found that cases where social rights eventually won over a fiscal discipline were not many. But again, my point is rather that we see that social rights have to be balanced in any case against fiscal discipline. That was not the case in the pre-crisis era. Now, a second comparative point is the treatment of judgments as fiscal liabilities. So, especially, I'm talking here about judgments that uphold social rights. So, the crisis brought a judicial innovation in some sovereign debt states, and this was that judges started containing the financial effects of their own jurisprudence and their own judgments, where the execution of judgments would be resource intensive. So, if, for example, say, an austerity reform or an austerity measure was deemed unconstitutional, then this meant that right holders had to be compensated, right? Or the values of benefits had to be reinstated. So what we saw in Greece is that judges started limiting the personal and temporal scope of their judgments by reference to the fiscal impacts that their judgments would have and how they would hinder fiscal stability and would mess up with the budget. So eventually, in Greece, this was eventually reflected in a legal reform that changed procedural law and gave the possibility to judges to balance, again, the effects of their judgments against the public interest that, again, had now assumed a new content by reference to the fiscal discipline. And this was gradually expanded to all apex courts. But in Italy, a similar approach was adopted by constitutional court judges, but not in social rights cases, in other in cases concerning tax reforms. But my point is that since we have this precedent, there is no guarantee that in the future, this approach will not be mobilized again to constrain social rights judgments and actually the actual restoration of social rights for right holders. And third and most importantly is that we see in both case studies an enduring impact of these constitutional rules on social and labor rights. So my point here is that this is not a thing. This is not something that happened during the crisis. This, until today, shapes the way courts, in my research at least, see fundamental social and labor rights. In Italy, fiscal discipline became a part of the constitution and a constitutional principle for good, exactly because it was entrenched in the constitution. And this means that the crisis-driven constitutional change continues to shape public policy and constitutional interpretation beyond the period of economic turbulence. It is a constitutional rule. It also means that this rule constrains future governments and future courts in how they decide. And we have seen, for example, recent cases in Italy where courts insist on a similar approach as in the aftermath of the economic crisis, by reference again to the balanced budget rule constitutional amendment. And this is also the case for Greece. And I want to show you this quote. So just to give you some background, in 2020, at the beginning of the pandemic, the Greek government adopted a law that basically compensated, in part, pensioners for pension cuts that were previously found to be unconstitutional. And the law said that pensioners would be partially compensated and the values of benefits would be reinstated, but this law also gave a waiver for other freezes and cuts that were considered as unconstitutional. Litigants turned to courts to challenge this law as unconstitutional, but Greece's Supreme Administrative Court did not agree with that. And here, the court recalled fiscal stability, which is important for the country to meet its financial needs in other sectors, such as health, defense, and the management of migratory and refugee flows. That is to say that the law that was adopted and scrapped off rights, actually, served objectives which in principle constitutes serious grounds of public interest. And this is what I find particularly interesting. So here, the court keeps using the principle of fiscal stability, placing social rights vis-à-vis other state functions, but detached from the crisis context. There is no mention to the euro crisis, there is no mention to a strained fiscal situation, to economic turbulence and economic emergency, nothing. So this is the legacy of mainstreaming these rules of fiscal discipline in the constitutional sphere. And I personally find this statement quite cryptic, and I'm happy to talk about it later, especially when it comes to the way it positions social rights vis-à-vis migration and asylum seekers' rights. But I'm happy to talk about that more later. Now, concluding, I'm wondering, I focused on Greece and Italy in this project, and when I talk about informal constitutional change in the case of Greece, but I'm wondering how many other EU member states that are currently under the radar of fiscal constitutional inquiry and EU law accounts have mainstreamed fiscal discipline in similar ways, and what does this mean about state functions? And I think that relevant inquiry can offer a better mapping of the current state and variety of fiscal constitutionalism in Europe. But a further important aspect that has emerged from the analysis is that, again, regardless of how EU fiscal constraints enter a constitutional sphere through formal means or by other means, they reshape the operation of fundamental norms, of fundamental principles, and in the field of social rights, this interaction has manifested itself in tensions and in the balancing of fundamental social rights and the perception of judgments upholding social rights as fiscal liabilities. But I think that we should also perhaps find value in investigating how fiscal stability restrains or prevents other types of responses related, for example, again, to the climate crisis, or whether ideas of fiscal stability have constrained state support for people in the cost of living crisis. Now, finally, The analysis has shown the long-lasting relevance of constitutional fiscal constraints beyond the euro crisis. And constitutional fiscal rules endure, and so do their limiting effects on social rights. And I think there is a paradox here that while EU's responses to the COVID-19 pandemic, especially with the Next Generation EU, created optimism for a shift from neoliberal retreat to public investment, and new legislative initiatives at an EU level gave rise to hopes for the return of social Europe, EU member states are still bound by onerous constitutional norms of fiscal discipline, both written and unwritten. Thank you very much.